Here are two common mistakes that you should avoid making early on when pursuing a wrongful termination case against your former employer. The first mistake is rushing way too much with the process and being way too eager to file a lawsuit against your employer as soon as humanly possible. You may be angry, and understandably so, about your termination, and you really want to take action as soon as possible. But in many cases, rushing with the process is not only not a great idea, but it can actually be counterproductive to achieving the best results from your case. And here is why. People who rush, people who are too eager, tend to hire the very first attorney who returns their phone call. Now, remember, the law provides you with time, with 6 months or a year, and often more than a year, to file a case. The law provides you with that time for a reason. The law wants to encourage you to research your claims, to consider your options, to talk to different attorneys, to maybe talk to potential witnesses and gather some evidence, whether before or after you hire an attorney, but before filing a lawsuit. Use that time. The process of litigation, the process of handling a wrongful termination will take months or maybe a year or even more. So whether you hire an attorney this week or next week or even a month later is not going to make any difference. It's not going to hurt you unless, of course, there's a statute of limitations issue. But if that's not an issue, it's much more important to hire the right attorney for your case, an attorney who is experienced, an attorney who you feel comfortable working with, an attorney who is prompt at getting back to you, an attorney who has maybe good references in addition to everything else, than hiring the very first attorney and then having your case mishandled and having that attorney make mistakes that are often irreversible in your case. So take the time that the law provides you, research the law, talk to at least 2 attorneys, get 2 opinions about your case in order to determine what to do and when to take action. The second common mistake that employees make who think about filing a wrongful termination case is doing things after their termination that damages their case or can damage their case. This often includes sending nasty emails to their managers or posting really bad, disparaging information, whether it's true or false, about their employer on LinkedIn, on Facebook, on Twitter, on Glassdoor, or wherever else. Often these accusations and those disparaging remarks appear to be exaggerated. Sometimes that information comes into evidence, sometimes it doesn't. But there is a risk that whatever negative stuff that you're writing about your employer, there is a risk that that information will be put on an overhead screen in front of the judge or in front of the jury, and the lawyer on the other side, if he is half as good as he should be, he's going to ask the judge or the jury, ladies and gentlemen, would you hire that person? Would you want to keep that person? Now remember, the judge, the jury, they weren't there when you were harassed, when you were discriminated. All they know is what they see, what they hear from you, what they hear from your attorney. But once they see your emails, once they see your postings, that negative information is going to have a big impact. Or at least it might have a big impact. So avoid this mistake. If you're terminated, there is no benefit whatsoever in writing nasty emails to your coworkers, to your managers, to your boss, telling them how you feel about them, telling them how you feel about your termination and how happy you are to be out of there. And there is also no reason to write bad things on different social networks or other platforms to voice your grievances. It cannot help your case. If nothing else, it will hurt. So avoid these 2 mistakes to help your case and to make the most out of your case. Thank you.